Recently, a viewer of Don't Talk TV very helpfully shared with me a significant decision in COVID-19 case law where an Ontario Court of Justice judge found that the insertion of nasal swabs into the body violates the provisions of the Quarantine Act. So today on Don't Talk TV, we'll take a quick look at that. Hello, my name is Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So it's late July 2024, and now finally we're starting to have some cases reach the point in the justice system where people who are issued tickets for various alleged violations of the Quarantine Act back in 2020, 2021 are now having their day in court and having decisions rendered. So as I mentioned in the preamble, a viewer of Don't Talk TV very kindly sent me an email with this case, His Majesty the King and Fernando, which is a summary conviction appeal case. This individual was convicted by a Justice of the Peace, appealed it to the Ontario Court of Justice, and the judge at the Ontario Court of Justice reversed the Justice of the Peace's decision. And I think he was completely correct to do so. So let's go straight to the case and have a look at that. Here's the case. You can find it on Canley. As always, we'll have the link to this in the show description. His Majesty the King and Metha Fernando. My apologies if I'm pronouncing that incorrectly. And it's a ruling of Mr. Justice Paul Monahan. This is in Brampton, Ontario, June 26, 2024. So just under a month ago as of the filming of this. So I go down here to discussion analysis. So he indicates that at the trial before a Justice of the Peace, Ms. Fernando was not permitted by the Justice of the Peace to rely on the Canadian Bill of Rights because there was no application before the court. So the Ontario courts have very specific rules that if you want to make a constitutional challenge, be it under the Charter of Rights and Freedoms or the Canadian Bill of Rights, you have to file an application 30 days in advance. Ms. Fernando, not being a lawyer, understandably didn't know that, but nevertheless, the rules are the rules, which goes back to why I believe lawyers are important and people should have some legal representation from a professional who would be able to know all these rules and follow them. But in any event, whether the Justice of the Peace should have let the defense argue about whether the Canadian Bill of Rights was violated or not is not necessary for me to decide, given my view regarding Section 14 of the Quarantine Act. So we'll see. Because of Section 14, he said, really, I don't need to even look at the bill because this case is decided because of the Quarantine Act itself. And the argument is laid out right here. The defense raised an argument before the Justice of the Peace and before me which has merit. The Justice of the Peace did not address this argument. The argument, simply put, is that the Act did not authorize a screening officer to use a screening test which involved the entry into the traveler's body of an instrument or other foreign body. So if we go down to page 6, the Justice goes through the analysis, noting, of course, the prosecution raised an argument of questionable merit, in my view, where they say that they raised the point that perhaps the insertion into the nasal cavity did not involve entry into the body. The judge disagreed. The insertion of a nasal swab into the nasal cavity is most definitely an insertion into the body. And furthermore, the prosecutor tried to raise the question of, is a nasal swab an instrument? And the judge said, in my view, a nasal swab is an instrument or foreign body. In my view, the Quarantine Act did not permit a screening officer in this case to require Ms. Fernando to be tested at the airport by insertion into her nasal cavity of a nasal swab. I am also of the view that the order, that being the order in council that required these nasal swabs, that order did not purport to expand the powers of the screening officers, and it could not do so as a matter of law. Therefore, the Justice decided that the nasal swab test, which the screening officer in this case required or demanded Ms. Fernando submit to, was an unlawful requirement or demand. Ms. Fernando's refusal to comply with the requirement or demand was lawful on her part, because you have no legal obligation to follow an unlawful demand. Because the requirement or demand made of her by the screening officer was not lawful, Ms. Fernando should not have been found guilty by the Justice of the Peace, and therefore her conviction was overturned. So certainly encouraging to see a decision like this. Now again, just going back to what I mentioned at the beginning, I think the reliance on the Bill of Rights in this case at the trial was problematic in a few ways. One, as I've discussed in previous episodes, the Bill of Rights wouldn't help here because although the Quarantine Act is federal legislation, what you're challenging isn't the Quarantine Act itself. In fact, she's actually relying on the Quarantine Act as being legitimate. It's this government action, the Order in Council, and government actions are more properly dealt with by the Charter, as I've explained, and the Supreme Court of Canada has said, and whether you agree with them or not, the Supreme Court of Canada is the ultimate authority on what the law is in Canada and how it's to be interpreted. So we're stuck with the Supreme Court's decision that the Bill of Rights only applies to legislation. So I think it would have failed even if proper notice had been given. But also, it obscured the real issue, and the Justice of the Peace then just ignored the real argument, the successful one, that the Quarantine Act did not authorize the insertion of an instrument into someone's body. So good result in the end, but probably some stress in the meantime since this person was convicted, ordered to pay over $6,000 in fines, and had to appeal. But again, it's good to see some good decisions starting to come. If you had a ticket and the only thing you were charged with was failure to submit to a COVID test, this is good case law to use. If you're convicted, you should appeal using this decision. This video in and of itself isn't legal advice. If you have a situation, you need to get specific advice tailored to the specifics of your situation from a lawyer. If you want that lawyer to be me, my contact information is below. And again, show topics always welcome. The last several episodes have been based on requests or suggestions, or in this case, someone providing us with information, so that's always welcome. But please, I stress, send it to the email address listed on screen. Don't send it to my law firm website, because there's a very low likelihood of me actually seeing it if you send it there. So please send it to the Don't Talk TV email address. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media.